Hey guys, this is Cave. It is Tuesday, March 9th. I am with 2008 Roseville grad Nick Pouladian. Nick is an attorney with the Legal Rights Center. Welcome back, Nick.
James, good to see you. Thanks for having me.
Of course, of course. So, got some questions about what happened today, and then actually a number of questions from our viewers. So
Sounds good.
let's hit those today. So, today, the jury the trial seated three jurors. Does the pace surprise you, or is that kind of about what you thought would happen, or the pace in which that would happen?
Yeah, good question. So it seems to be going about on par, I think, with where Judge Cahill wants it to be. He had talked about trying to get through an interview, seven witnesses in the morning and potential jurors in the morning and seven potential jurors in the afternoon. Something that's sort of, I think, for every attorney who's watching this to keep in mind is it's a very different method of doing it than we usually do. Number one, most cases aren't of this magnitude. Number two, usually we're not dealing with COVID. So there are some cases where you do the questioning one at a time. Sometimes if it's criminal sexual conduct cases involving young kids, really, really, really emotionally charged things, you might do that one at a time. But typically all of the potential jurors are in there at one time, so you're not doing it one by one. The other twist to it are the questionnaires that were sent out. That doesn't typically always happen either. So it usually is sort of a much longer process of when the jurors show up. You have some background information on the jurors, like their age, their occupation, the occupation of their partner or spouse, if they have one, some of their children, and the judge does broad stroke questioning of all of them. So it's really, on court TV, one of them said it can be like kind of watching paint dry. So it can be a much longer, drawn-out process. Some of that was saved because they filled out these questionnaires months ago at this point. So the attorneys, and I think they said they're like 20 pages. So the jurors already gave a lot of information, and the attorneys had a lot of time to digest that information, even coming into it. And one correction I'll add too, we talked about this last time. On the questionnaire that was sent out, it does explicitly say and reference and let folks know that, hey, this is going to be for the trial involving the officers in the death of George Floyd. So the jurors absolutely did know that when they were filling it out. Like we saw them talking about today, that made me think, oh, hey, I should double check that. So I'm going to fact check myself. They did know about it coming into this.
Sounds good. I also found it unusual today on Star Trib. I noticed that the three jurors who are seated, they actually gave a biography and some of their feelings, like maybe some of their statements about if they could be a juror and have an open mind. Is that common to have that kind of information about jurors?
Yes and no, right, to an extent. So court proceedings are, with rare exception, open to the public, right? So if you wanted to take your students on a field trip one day under normal circumstances and go downtown to the Ramsey County or Hennepin County Courthouse and watch a jury trial, you would have the right to go do that. You can sit in there and you could listen and watch jury selection. And because it's open, if you're in there, in this case, it's journalists who are in there being able to listen or watch, whatever's being broadcast is public information. So if they're, for example, talking about somebody being a chemist, if they're talking about, the race of somebody or their leanings to one of the questions they answered, that is public information and that can be published. The prohibition and the restriction here is sort of the more specific identifying information, right? So it's juror number 4, not Mr. or Mrs. X, Y, or Z.
Right.
The judge is doing everything he can to not have folks know that. But the more general information, anything that we can hear, it's public and that can be shared out in the open.
One question I want to kind of backpedal a little bit, and you talked about usually the potential jurors are all together being questioned, and with COVID, they're separate. Do you have any idea once the trial starts, will all the jurors be in the jury box? Will they be separated by plexiglass? Will they be watching Zoom from another, 12 other rooms, or do you have any idea about COVID precautions once the trial starts?
Yeah, good question. So my understanding is that they're using a courtroom that is going to be big enough to fit the 12 jurors in there and accommodate social distancing. So I presume they will have them wear their masks. Typically, a jury box, it's pretty tight quarters, right? Think of like being at a movie theater. 12 folks at a movie theater, you're right there next to each other. Somebody's legs are bumping. The chairs might not be that comfortable. That's under ordinary circumstances. In this case, I think they're marking off every 2 chairs. They're, at least, and then they're even having jurors sit back in the gallery. So the area where the quote unquote crowd could usually watch. So all the jurors should be in the courtroom. They'll be a bit more spread out. It's just an awkward setup to be COVID safe, or as safe as it can be. But they'll be there in person and they'll have masks on. They'll be distancing.
Okay, great. Thank you. So what I want to do, Nick, if this is all right with you, is I have some questions from followers of Not Your Teacher 651 on Instagram, colleagues, former colleagues. So let's just make this a Q&A if that's good with you.
Sounds great.
So while we're talking about jurists, a former colleague of mine asks, if the jury is sequestered, do they get to keep their phones? Do they get to have contact? Can they talk to their family members? Can they have visits with family members?
Really good question. So the short answer to that is I don't know. I don't want to start saying things that I don't know for sure. What I can sort of talk about
that never stops me, Nick. So
I have to start following your Twitter account now. It's going to be beautiful.
Yeah, it is.
So let's talk about an ordinary scenario, right? When throughout the trial, the jury is directed, and you've seen Judge Cahill do it today. Say, hey, you know what? You can live your life. You can go out. You can go home, but you can't talk about the trial. You can't tweet about it. You can't read about it. All these things. When it comes time to actually go back and deliberate, that's under ordinary circumstances when the jury is sort of sequestered in that sense, right? Yep. So the deputies do take their phones and you get locked in this tiny, tiny little room. And there's even a bathroom in that room that you're supposed to be using. So while you're deliberating, you're not making outside calls. You're not checking your phone. You don't have access to email. You can't have visitors, nothing like that. So if the judge were to do a full-blown sequester, scenario where he's going to keep the jury in the hotel under guard, I don't know. They might be able to make calls to family. I'm honestly not sure. I think that would be maybe for folks around for the OJ trial or the Rodney King trial. I'm not sure if they're all sequestered there, but that's a good question. But under ordinary circumstances, when it comes down to saying, hey, we're going to come up with a verdict, you're shut off from the world and you're focusing on the case.
Okay. This is a question from the same former colleague. So we had talked about, I think yesterday or one of the previous episodes, that Derek Chauvin is out on bail. And, I guess we assume he's at home. I don't know. Does he just drive himself to court every day? Or, does he drive himself to court every day?
Yeah, that's a really good question. I think on its face, that a lot of people are very upset with him. So you would think he would have some safety concerns, especially, he's going through a divorce right now. So I don't know if they've sold the home or if he can stay there. I would assume he's staying at an undisclosed location, maybe a concrete bunker. I mean, he is obviously very much not a popular person. And I mean, just thinking about it, like on lunch breaks, I'm sure I would be shocked if he's even kind of walking around the Skyway getting himself lunch. I'm sure he's being protected and trying to be as low profile as he could be.
Would Hennepin County be in charge of protecting him?
I would assume so, on the premises at least. Outside of that, once he leaves the building, I really don't know. Okay. That's a super good question. Yeah.
Okay, great. I have a question from esteemed teacher and colleague Ira Sanders, and he asked, does third degree charge add any more possibilities to sentencing, and can it help get a conviction? We're still waiting, and we talked about this in length yesterday. We're still waiting for that third degree charge, the decision on the third degree murder charge, excuse me. So by adding that, is there any possibility for more time or more possibility for conviction?
Yeah, so and I'll kind of go in descending order. So the charge in which he could get the most potential prison time would be the second degree unintentional murder charge. That carries a statutory maximum of up to 40 years in prison. Assuming the third degree charge gets brought back in, but even on its own, the statutory maximum for third degree murder is 25 years. So obviously that's still a substantial amount, but significantly less than 40 years, right? The second degree manslaughter charge that's in there has a statutory maximum penalty of 10 years, right? So you really kind of see that highest, middle, 10-year drop there. Mm-hmm. Now, what we had talked about earlier is when you look at the sentencing grid, and we sort of talked about this presumptive sentence, the presumptive sentence, if he were to be convicted of second degree unintentional murder and third degree murder, they carry the same presumptive sentence, right? In this case, the state is pursuing what's called Blakely factors. Those are aggravating factors to say, hey, judge, or actually jury and judge, we're going to prove to you beyond a reasonable doubt that this crime happened. And we're also going to prove to you beyond a reasonable doubt that there were certain things surrounding it that made this crime worse, more heinous, aggravated than the typical crime. So a few of the things that the state is going to be pursuing is saying, not only did Chauvin commit this crime, but he did it from a position of authority, right? He was a police officer. Not only did he commit this crime, but he did it knowing that the victim, George Floyd, was particularly vulnerable. He was particularly vulnerable because he was handcuffed on the ground. Not only did he commit this crime, but they did it in the presence of children, right? There were, I think, some minors in the Cup food store, right? Okay. So if they prove those beyond a reasonable doubt as well, then the judge could sentence Chauvin beyond that presumptive 150 months, right? He could then get up to the maximum 40 years. So for the third degree murder, I think the second part of that was, does it increase the likelihood of a conviction? That is a really, really good question. And I think depending on who you talk to, there are going to be a lot of different answers. So I was just talking with my wife about this today. So my personal opinion, and I'm not the end all be all, folks might very well have different opinions than me. My coworkers could even watch this and say, hey, I think differently. So I'll caveat it with that. Second degree unintentional murder is saying that Derek Chauvin caused the death of George Floyd, and he caused it while committing a felony, right? An underlying felony that the state would say he was committing was assault in the third degree. Kind of a Russian nesting doll. Assault in the third degree says that you intentionally inflicted bodily harm on somebody, and that bodily harm was substantial, right? In this case, so the intent to commit an assault is not that I meant to hurt James or I meant to inflict substantial bodily harm. It's I intended my actions. I intended to move my arm. I intended to place my knee there, right? Doesn't matter if I intended to break your neck or if I intended to break your eye socket. I intended my action, and that's enough. Mm-hmm. If I were having a seizure or, sleepwalking or something like that, then you could say, hey, no, that was an involuntary movement, right? Nick couldn't control his arm there. So in that case, under the second degree unintentional murder case, they have to prove the cause of death. That'll be a point of contention for any charge, right? Yeah. That's going to be debated back and forth. But I think the state has an easy job to say, hey, yep, he knelt on him. His knee is on his neck. He intended to do that. The harm was substantial. The only thing to fight about then would be, was that use of force reasonable, right? And again, this is my personal opinion. I think all you need to do is watch the video. And my opinion is that clearly that use of force was not reasonable, right? So you don't really even have to get into, was his mindset depraved? Was it reckless? Was it eminently dangerous? Was he culpably negligent? I think all those things are also true. But I think the second degree charge potentially is an easier one, or just as easy to prove. Okay. One of the thoughts in terms of having the third degree is to say, hey, sometimes juries like to split the baby, right? If they, hey, these are both extreme. We don't want to go with the most extreme, so maybe we'll go with the next extreme, right? So that could be why the state would be really pushing that third degree to say, hey, if you folks don't go for second degree, at least go for third degree.
Yeah.
A jury could go with that to split the baby, and we could still get 25 years for that. Second degree manslaughter is still up to 10 years, but I think, 10 years in light of what happened is, I think a lot of folks might think, hey, that's really not a victory here.
Yeah. So off of that question, if Derek Chauvin is convicted of multiple offenses, do those add on top of each other, or do they say, well, the 25 years is within the 40 years, so it's just 40 years? Or is it, wow, 40 years and 25 years, he's convicted for prison for 65 years? You know what I'm saying?
Yeah. Yep. So when there are multiple charges coming out of like one or multiple charges coming out of one course of action, you're sentenced on the most severe one, right?
Okay.
So in this case, the jury, let's say the jury says, yep, we're finding him guilty of second degree unintentional murder and manslaughter, right? But let's assume third degree is out.
Yeah.
They would sentence him on the second degree unintentional murder. And the manslaughter would be noted as a conviction, but it wouldn't be sentenced. Wouldn't be sentenced on.
Gotcha. So not added on top of each other, just kind of included. Whatever the max is, the max presumptive sentence is what it will be. It's not added together.
Right, for the most severe one. Yep.
Gotcha. This is a question from Junior Laura Jennings, excuse me. And she asked, how long will this trial go? Is it weeks? Is it months? Is it years? Give us longest case scenario, shortest case scenario, and then maybe what you think. Yeah,
so what Judge Cahill is saying is about 3 to 4 weeks starting March 29th.
Okay.
So I think they're expecting, end of March, most all of April, for actual substantive trial moments, right? Opening statements, witnesses, evidence, videos, photos, all those things. So they expect about 4 weeks, and then after that, it would go to the jury, and the jury could take, a few days, a few weeks, however long that might take. So I think realistically, we're looking in the total probably 5 to 6 week mark to sort of wrap everything up and get a verdict.
Okay.
If I had to guess.
Right. And then who knows, right? Who knows?
Right. And follow up with that, we're certainly going to see appeals, right? I mean, there are already appeals happening surrounding issues here. And then with, assuming there's a conviction, there are going to be a plethora of appeals that presumably the convicted Chauvin would be filing at that point too.
A lot of kudos to the English and literature teachers at Roseville. You have a lot of really big words.
Law school Mike was upheld. Yep, exactly.
Awesome.
So I know that was a long mouthful. Sorry about that, but that's just sort of a winding process.
People will get a minute into this, and they're not even going to be hearing this part of the.
I'm sure. Yeah, they're probably logged off much earlier than this. Yes.
Yeah. They get the first minute on Instagram, and then after that, they have to click, and no one's clicking. But anyway, we'll keep our head down and moving through. Appreciate you, Nick, and we will talk again soon. Thank you very much.
Thanks, James. Take care.
Bye.